Start. The matter dragged on since 2003 till 2008 when a SOCAUS was issued upon the private respondent as to why he should not be punished. He was again dismissed from service a fourth time over on 21/4/2008. This order was again challenged. The learned single judge, after going through the entirety of the issue, found a serious omission on the part of the appellants where the inquiry report was not supplied to the private respondent. A specific plea was taken in the second SOCAUS about non-supply of the inquiry report by the disciplinary authority, but all that was ignored, and then the order of dismissal was passed, which was challenged in the writ application against which the present appeal has been filed. From the narration of facts as well as the history of litigation, it is evident that there is something amiss in the manner in which the inquiry was being carried out without following due process, and repeated orders of dismissal came to be passed against the private respondent, which was not supported by law, or else the High Court would not have set aside such orders. It was in this background, and again finding that the dismissal order has been passed despite non-service of copy of inquiry report and refusal of the authorities to follow the norms, compelled the learned single judge, in the peculiarity of facts and circumstances, to allow the writ application and set aside the order of dismissal. The court also imposed a cost of rupees 10,000, which was payable to the private respondent. Now, the appeal has been filed. Submission of the counsel for the appellants is that the learned single judge, while setting aside the order of dismissal, could have very well remanded the matter back to the authorities from the point from which the procedure was found to be faulty. Such a submission does not merit consideration in the present appeal, looking at the fact that the initiation of the departmental proceeding was made in the year 1995, and 22 years have gone past the 4 orders of dismissal which came to be passed by the appellants against the private respondent were repeatedly found to be illegal and erroneous in the eye of law. How much more of punishment and harassment could an employee be permitted to undergo only to satisfy the whims and fancies of some authorities who may not be favorably inclined towards the private respondent? अगर डिक्टेशन अच्छी लगी हो तो प्लीज़ सब्सक्राइब करें. जितने भी हाई कोर्ट से रिलेटेड वैकेंसीज़ आ रही हैं, जैसे पटना हाई कोर्ट और चंडीगढ़ हाई कोर्ट और झारखंड हाई कोर्ट की वैकेंसीज़ आ रही हैं, उनसे रिलेटेड लीगल डिक्टेशन आपको मिलते रहेंगे इसी चैनल पे.